This is a lecture from Open Tuition. For the free lecture notes that go with this podcast, please visit opentuition.com.
Chapter 18 deals with legal obligations that are imposed on organizations. Legal obligations could be discussed on the environmental analysis, where we looked at PESTEL, political, economic, social, technological, ecological, and of course legal. But there can be quite a lot of material, if you like, on the legal, so it's been split out into a separate paragraph. First, we look at the potential sources of law which are going to affect organizations. And in general, not for every country, but in general, you can have these sources. For a country which is a member of the European Union, then we have European Union or European Community law. And there are effectively two ways in which those laws can be brought in. First of all, there can be a regulation which is passed, and that automatically becomes law in each of the member countries. The alternative way is that a directive is issued, and this is essentially a directive to each country's government to enact their own version of a law. So national laws there can be altered. They will be very slightly different between different countries, but essentially the spirit of the directive will have to be met. If a country isn't a member of a kind of a supranational organization, then of course it will have its national laws. And typically the national laws are passed by the government, by whatever it's called, like the Senate, the House of Representatives, Parliament. The different countries have got different names for the legislative assemblies. And when the Legislative Assembly passes a law, it will be in statute. Statute is really the name given to a written law that's been carefully drafted to fulfill certain aims and ambitions of the legislators. Some countries, for example the UK, also have a system of case law. Case law can be common law, equity, or the terms involved with it are common law, equity, and precedent. Basically, case law is court-made law. The courts, the judges can't invent completely new laws, and certainly a statute is much more powerful than case law. But quite a lot of, for example, the law of maybe assault, or the law of theft would have originated from case law. One can imagine no law was ever passed by the Legislative Assembly, but almost from time immemorial, theft and assault and murder were illegal. And over a period of time, different cases would come to the courts, and the courts would, if you like, refine the law. So they would maybe have different degrees of assault. They would maybe make allowances for diminished responsibility, maybe allowances for self-defense, and so on. Equity is a branch of case law. We didn't get into that too much. But it used to be that common law had very little flexibility in it. Equity allowed judges to have more discretion. And the idea of precedent is really recognizing it's quite important for people to know what the law is, what the case law is. And what precedent means that if a case has been decided at a higher court, then lower courts have to follow it. So for a period of time, the law is certain, not until the higher courts change the law, would it be changed. The types of law we need to look at, the first is the Data Protection Act. This was in the UK, a European Union directive. Many countries have some form of Data Protection Act. They'll be slightly different, but I think one certainly does need to be aware of the main principles involved in data protection. And of course, the reason that the law was drafted was that more and more information is held on computers. It can be shifted around from company to company and from country to country very easily. It's very easy to search this data, to hold it for a very long time, and so on. And people basically began to be worried about privacy, our desire for privacy, our rights, and so on. And here are the main principles. First of all, that the data shall be processed fairly and lawfully. And this in the EU means that if a company is holding data on a citizen, then they have to basically say for what it's going to be used. And they generally have to register with some sort of data protection registrar. And they say, I'm holding this data so that I can send maybe people special offers, or I'm holding this data because this is the way their bookings on the airline is going to be remembered and so on there. And if they say it's being held for booking purposes in a hotel or an airline, that can make it lawful, but it means that they couldn't potentially use it for some other purpose. It shall be obtained only for one or more specified and lawful purpose. Again, this is, if you like, following up a little bit more specifically here. The uses of the data, how you get it, and so on, has to be fair, lawful, specified, and so on. You're not supposed to hold data just in case you might need it. The data shall be adequate, relevant, and not excessive. You can't go on kind of fishing expeditions, so to speak, to collect lots and lots of data once you've registered maybe for one purpose. It shall be accurate, and that means keeping it up to date. It also means that citizens are given a right to correct incorrect data, so that they will not be damaged in some way by wrong information being held about them. And it shouldn't be held for longer than is necessary. These principles, if you like, data protection principles, really affect most businesses. There are certain exceptions for government and so on, for example, for security services, where maybe you don't have a right even to see your data, know about it. But within these principles for ordinary organizations, you have a right to see your data in many countries. The data shall be processed in accordance with the rights of the data subjects under this Act. The data subject is the person about whom you're holding the data. And for example, we have to be mindful of what we do with the data, not to infringe the rights of people. We have to make sure that we safeguard the data here. Appropriate measures taken against unauthorized or unlawful processing, against accidental loss, destruction or damage to the personal data. So leaving, let's say, a disk or a file in the back of a taxi is certainly going against the data protection regulations and principles, because then it means that somebody else can use that data. If you are transporting data around the place, it implies there's maybe a requirement to encrypt it, so that if it does go astray, it doesn't mean much to people. And finally, the personal data shall not be transferred to a country or territory outside the EU, because unless that other country has got similar levels of protection, because you could kind of see a way around this. A company in the UK, to escape this legislation, transfers the data to a country where there is no legislation, and then it can process it for whatever purpose it wants. So this kind of maintains these principles as best it can. We have to be aware of the risks to data which can occur. There can be a human error. For example, you simply input the wrong information. You input somebody's date of birth incorrectly, you input perhaps their salary incorrectly, and so on. And there can be implications there maybe on banking and so on. By putting in wrong salaries, maybe you don't get your bank loan. And we have to be aware that this data, if it is wrong, could be causing harm to people. And we have to try and take measures to stop it. Maybe we put the data in twice, maybe there's some other way of verifying that it is correct. Technical malfunction or error. What happens if you are relying on your bank and the bank internet system breaks down, so you can't get money out of the automatic teller machines, you can't make payments in shops and so on. It could be that the data, for some reason, the computer, the heads crash and the data is lost perhaps forever. There can be catastrophic events. Catastrophic events are things like fire, flood, earthquake and so on, where not just the data is destroyed, but perhaps a whole computer installation is destroyed. And many companies where they rely on data being available and data processes being available really 24 hours will often have a kind of mirrored system in a remote city. So if there is a real catastrophe in one place, they just switch to the other one. Malicious damage. Malicious damage can be viruses. It can be people hacking in and changing the information. There have been instances of what's called denial of service, where somebody organizes for an internet site to be bombarded with requests, and so many requests keep coming into the internet site that it eventually crashes. Industrial espionage or sabotage. Considerable talk about this now, about how maybe countries or rival companies can get access to a company's plans, for example, maybe their budgets, maybe their plans for new technology, and then they suck this information out and it allows them to perhaps copy or at least react to those plans. And finally, there is dishonesty, essentially fraud, people altering data to their own advantage, or indeed, of course, altering programs to their own advantage. It's easy to put in a little decision to a program so that, you know, if the employee equals me, then the salary is 10 times what it would normally be, and so on. And it's very important that both data and software is properly tested. We turn now to look at health and safety. We're looking at obligations that employers have to keep their employees safe at work. Again, this is kind of modeled on EU law. I beg pardon, this is modeled on UK law here. But many countries will have very similar pieces of legislation, and it's important to kind of appreciate the principles which are in place here. So it says that all work practices must be safe. So, for example, if somebody is driving a forklift truck or something of that sort, there has to be a limit on the weight that can be put on the truck so that it doesn't fall over or so on. If you're stacking barrels of stuff up in the warehouse, again, you'd be expected to take care that there was no chance of those falling over and injuring people. The work environment must be safe and healthy. This can be noise, it can be pollution, it can be the temperature in the work environment, and so on. Within factories, there are usually very carefully marked out lanes. This is where you can walk, and this is where the machinery moves, and so on. You have to maintain plant and equipment to the necessary standard, because once it deteriorates, then of course there's a danger associated with it. Maybe an electrical contact loses its insulation or something of that sort. You have to train people to take health and safety seriously. You have to supervise them. You have to essentially potentially make it a disciplinary matter if they don't follow the safety rules, because not only are they harming themselves, they're harming the business if the business has to stop for a while, and they're potentially harming their colleagues. So it's really very important. Clear communication of safety policy to all staff. There could be, for example, a handbook. And employers have to carry out risk assessments. And these risk assessments can, on one level, almost seem to be trivial. For example, if you were in the kitchen of a restaurant, the restaurant owner has to carry out a risk assessment on what could go wrong. If you're chopping vegetables, and obviously what could go wrong if you're chopping vegetables is that somebody cuts their finger. What could go wrong if you're opening a tin of beans or something like that? What could go wrong is, again, somebody cuts himself on the sharp edge, and so on there. And once you perceive a risk, you have to either decide that it's actually quite trivial, and it really doesn't, there's a risk there, but it's terribly unlikely it's going to happen. If it did happen, it wouldn't really harm anybody very much, in which case you've assessed it as being of non-importance. But some other risks, you'd say, well, if that happened, then there's a fair chance it would happen, then it could cause some considerable damage, and then you would have to take action. So in terms of a new recruit to the kitchen, and you set this new recruit to be chopping vegetables, it would be important that they were given training in how to chop vegetables so to keep their fingers out of the way, and not just let them, rely on luck, if you like, that they adopt the right procedures. You should share hazard and risk information with others, both inside and outside the organization. That's the way you maybe prevent more stuff going wrong in the future. We've talked about controls to reduce risk. Some controls are that someone is not allowed to work on their own in a factory, because if you're working on your own in a factory and there is an accident, there's nobody to raise the alarm, and so on. You have to keep the safety rules and regulations and policies up to date, identify employees who are maybe at a particular risk, and protect them and train them, and so on there. You may need to take specialist advice, and we may need our health advisors in there. And then what happens, we will normally have a safety representative appointed for the factory here. They're entitled to paid time off work to carry out their duties. This is a representative for employees. And they can go around and they can be looking at machinery, looking at work practices, and they can say, well, this is where me or the other employees might possibly be injured, and we need to do something about it there. And most large factories will have a safety committee where the safety representative, perhaps the production manager, health and safety advisors, and so on, they all kind of get together, discuss the issues, assess how dangerous the situation is, what exactly the risk is, and decide what, if anything, they need to do about it. Now, the health and safety is not all just on the employer's duties. There are employees' duties as well. Employees have to take reasonable responsibility to take care of themselves. For example, if an employee is taught how to do something and knows that there are rules and regulations about exactly how to do something, that, for example, you have to keep a particular safety device on a machine so that there's no chance of you putting in your hand and being kind of damaged or something. If the employee were to take that safety device off the machine, thereby making it dangerous, well, that's going to be a disciplinary offence. So it is. They have to permit the employer to carry out any safety maintenance and inspections which are required. They mustn't interfere with machinery or equipment. That's kind of reiterating or a specific example of taking reasonable care there. You have to alert the employer if you see something which is wrong. So if you see a machine which is perhaps in need of maintenance, then there's a duty to tell the employer that. And you have to use all the equipment properly. So switch it on the right way, switch it off the right way, only put in the correct material and so on. And I know I have a friend who has a printing business, and in the printing business, there are what are called great guillotines which come down and will slice through, a lot of paper or card to produce the final product. And quite obviously, there's a big danger that somebody's hand is in there when this guillotine comes down and amputates their hand, really. And the way that the health and safety is sort of enforced there is that to get the guillotine to come down, there's a button there and a button there. So both have to be pressed simultaneously. They have to be kind of pressed within a fraction of a second of each other. So you need your two hands to do it. You can't do that. But what he discovered some of his employees doing, I'm not quite sure why this was handy, whether they were holding the paper or something. What they were doing was pressing one button with a left hand, raising their foot and kind of pressing the other button with their foot, and the other hand, of course, was free to go into the machines. So that's an example of not taking reasonable care of yourself and so on, an example of not using all the equipment properly. And again, that would be a disciplinary offence. Similarly, in building sites, you will see everybody's wearing hard hats and so on. And if they don't do that, they're likely to be, again, disciplined. Employment protection is, when extending from health and safety, employment protection looks at how safe your employment is, not physically safe, but how easy it is for you to lose your job, really. And there are, again, this is modelled on UK legislation, but we have to have some idea how the law can protect employees. And we're looking here at termination of employment, and it can be really three ways. There can be retirement, when you get to the retirement age, resignation, maybe you want to move to another employer, and then there can be dismissal, which is basically your employer telling you to go. And in termination, there are three, in dismissal, there are three types. There is termination, which is basically the sack. There is non-renewal. And non-renewal is where you have a limited term contract, let's say for 6 months, and it comes to, well, let's say for 3 years, you're employed for 3 years. It comes to the end of 3 years and it is not renewed, then that is dismissal. And there's something called constructive dismissal, which is the interesting one, which is basically that the behavior of your employer has been so outrageous that you're entitled to assume that it amounts to dismissal. So if your employer were to um, almost withdraw work from you, so you're kind of sitting there idle, maybe in the hope that you get fed up and you actually decide to leave, then that may well be regarded as constructive dismissal, that there's been a kind of ploy going on there to get rid of you. We'll just look at what amounts to fair dismissal here. Again, it's UK based, but it's interesting to see, I think. Someone can be made redundant. Strictly means that the job is made redundant. We don't have that job position anymore, and someone can be dismissed because of that. There could be a legal impediment. For example, if the law were to change and didn't allow anyone below the age of 18 to work in a particular field, then you'd be legally dismissed. If the law were to change and say, well, let's say women who were pregnant are not allowed to work in a particular part of a factory, perhaps because there's a danger to their unborn child, again, that might be a legal basis for dismissal. Non-capability means you can't do your job. You might be incompetent. This is maybe a very common reason for dismissal, but it has to be fair. You have to give people the opportunity of becoming competent. You have to give them time to do that. You maybe have to give them training to do that. But if you've given them training, if you've given them time, and they still can't do it, then they can be dismissed quite fairly. Misconduct. Again, misconduct is a bit of a variable here. What amounts to misconduct? Does leaving an unwashed coffee cup on your office desk amount to misconduct when really the office rules say that you should be taking them and washing them up or something? That would be a pretty trivial form of misconduct. And it goes all the way up to very serious forms of misconduct, where maybe you get fed up with a customer and you hit them, or you hit your boss and so on. That will be called gross misconduct. Gross misconduct, you go out then. If it's a lesser misconduct, then generally speaking, you have to be given some warnings. Verbal warning, a written warning, a final written warning, and then you're out. But again, it's intriguing. What happens if somebody's given several warnings, they behave well for 9 months, and then they do it again? I mean, is this starting the whole chain again, and so on? And maybe then there's a kind of catch-all here, some other substantial reason here. Maybe another substantial reason could be that you are married to someone who works for a rival. And if you're married to someone who works for a rival, then obviously when you and your husband and wife go home, you're kind of talking to each other, there is the danger of commercial secrets passing from one to the other. And there is precedent for people losing their jobs because of close associations with people working for rivals. I don't think we need to look too much at this here, but for example, pregnancy is not grounds in the UK for dismissal. Indeed, you have to keep the job open for the woman returning after she's had the child and so on there. Being a member of a trade union, again, is not grounds for dismissal, and so on. Now, if you are unfairly dismissed, what you can do is you can take your employer to a tribunal, an employment tribunal, and basically it's a court, and they will hear the case. And if they find for the employee, in other words, that they have been unfairly dismissed, there are 3 remedies. First, they could say, give this person their old job back. And it's very unusual for that to happen because this whole legal process takes some months, and almost certainly their old job is now occupied by another person. And if their old job is occupied by another person, they obviously can't get their old job back. Secondly, it can be re-engagement. You give the person a job which is of kind of comparable standard, comparable sort of pay and so on to their old one. But there mightn't be a job like that. And of course, you must realize that by the time everyone's gone through tribunals and so on, there's a lot of bad feeling in there. The normal one is compensation here. You give somebody basically a payoff to compensate them for redundancy, maybe breach of contract, and sometimes there's a punitive award, which is where the awards can get very, very large indeed, as a kind of punishment to the employer for operating in, acting in a particularly bad way. UK law and many other laws, many other countries' laws also protect employees, both at the stage of being appointed as new employees and further on under equal opportunities. And in the UK, we have got equal opportunities for dealing with race. So whether someone is white or black or whatever their race is, we have to not discriminate on appointing them or promoting them or training them. Sex, male, female, we have to be very careful to treat them carefully on appointment and training and promotion and so on. Disability, there is legislation in the UK that people with disabilities, you have to make reasonable adjustments to the workplace so that people with disabilities are able to work there. Reasonable adjustment depends to some extent on the size of the company. If it's a very small family company with maybe 3 employees, then it might be impossible to afford to put, say, a lift in, an elevator in to the workplace. If it's a very large organization, you would expect that to be done. Religion, we are not allowed to discriminate on the basis of religion, sexual orientation, and more recently, age. You're not supposed to be discriminating on, again, appointment, training, promotion, and so on, depending on someone's age. Obviously, some of these can maybe be hard to enforce, but there are cases arising all the time on this, where somebody says, I'm male, or I'm female, you're male, I had even more of the right qualifications, more experience than you did, you were the one who was promoted and so on there. And when any of this equal opportunities legislation is breached, it tends to be very, very expensive for the employer. There are 3 offences, if you like, under equal opportunities. There is direct discrimination, which could say salesman wanted. So right in the front of you, there is an implication saying sales women are not wanted. There can be indirect discrimination, which is quite a subtle one. A not very subtle example would be salesperson wanted, must be 2 meters tall with a large black beard. And that obviously is favouring male applicants and so on. And then there is a victimization. Victimization really happens after there's been some sort of tribunal hearing. The person comes back to work perhaps, and because they've taken the employer to court, they are victimized, they are unfairly treated because they had the nerve to take the employer to court. Diversity. Diversity means essentially having a mix of people in your as your employees, which reflects the population as a whole. And there are good, hard-headed reasons why one should go for diversity. First of all, you will be increasing the number of potential candidates. So let's say that you were an organization which historically had only employed males. then 50% of the population is never given a chance. 50% of people with talent are never given a chance. And why on earth would you decide to reduce the potential employment pool? Secondly, diversity. How can you sell to a whole population if all your salespeople are male? Is really what we're saying. It doesn't look maybe terribly sensible. So if you're going to be regarding as potential customers, males, females, older people, younger people, white people, black people, and so on, it makes sense, really, that your employment kind of patterns kind of match that. Third, diverse people bring diverse skills. If you are not diverse, it implies a kind of monoculture. It implies maybe that the only people you have recruited are people a bit like yourself. So you get quite a blinkered view of what's going on. And people from different backgrounds with different skills and different perspectives will presumably help. And third, diversity and flexibility in employment, again, will make you an attractive-looking employer. Many of the best people will not actually want to be employed by employers who seem to be in some way unfair or discriminatory and so on. They say, this is not the sort of business I really want to be associated with. Consumer protection, just a small bit on consumer protection. Contract law. Contract law was originally in the UK was part of case law. You'd find much more about it in F4. But contract law allowed binding contracts to be made. I promise to do this, you promise to do that. I promise you to pay you $10, you promise to supply me with that product. So everybody knew where they stood. And if you didn't supply me with that product, then I could take legal action, essentially. The goods had to be accurately described. So there were, if you said, I'm going to be selling you a new product, and you sell somebody a second-hand product, then of course that would void the contract, and you could take legal action on that. And the legislation also began to bring in, but part of contract law, unfair terms, were perhaps the detailed terms of a contract was page after page after page of what we call the small print. And buried in that, there was some kind of a paragraph saying, under no circumstances whatsoever can you get your money back. That would be regarded as unfair terms, and that would not be upheld by the courts. The consumer legislation, which is brought in examples of it, we have a list of it here. This should be saying a cooling off period. Cooling off period is one example. If people take out, say, insurance contracts, these can be quite large, expensive type of contracts. In the UK, you are given 14 days to reconsider. And provided you haven't made a claim within the 14 days, you can get your money back or the unexpired 50 weeks of that and so on. And this is to protect the consumer, where perhaps they were under some skilled salesman's pressure to buy. And almost this person had almost to get rid of them, you sign the dotted line, but then at home you think, do I really want to do that? Should I have shopped around a little bit, and so on. And then we have a lot of consumer legislation all over the place. If goods don't work, if they're dangerous, if they're not in the right standard, and so on there, it makes it a fairly easy statutory right, if you like, for people to be able to return these goods to the shop within maybe a certain time period and to get their money back or to get the goods replaced free of charge.